Hey everyone, welcome to another week of KNR 462. This week we will continue with our unit on negligence, but this week we're going to switch perspective a bit and look at negligence from the perspective of the defendant. Last week we looked at negligence from the perspective of the plaintiff, right? We looked at the different elements that were required in order to prove negligence in court. This week, we're going to look at potential defenses available to someone who might be sued for negligence, so a sport organization or individuals working within a sport organization. So that will be the first part of the module, and then the second video will focus on some of the different applications of a negligent lawsuit in the sport industry, so some of the different common lawsuits that we see in our field. Okay, as you know from your reading, there are a variety of different defenses available to someone being sued for negligence. So if we remember back to last week, we know that the burden of proof in a negligence case is on the plaintiff, meaning it's up to them and their legal team to prove those four elements. But again, our focus this week will be looking on what potential defenses are available to the defendant, the person or organization being sued for negligence. And as you can see and as you read, there are a variety of defenses available potentially in these cases. So just because the plaintiff is able to prove all four elements doesn't mean they will necessarily be successful in court. If the defense is able to prove one of these defenses are viable for them, they can still potentially win the case. One thing to mention before we start digging into these different defenses is that it's important to keep in mind that every state is different, meaning that every state has their own laws surrounding different negligence defenses. So what might be true in Illinois may not be the case in Indiana or Iowa or California or New York. So just keep that in mind that as we're looking at each of these, we'll speak a bit generally about them. In some cases, I might tell you, exactly how the law is applied in Illinois. Just for reference, but just know that every state is different. And if you do happen to move jobs and move to a different state, it's probably always smart to kind of catch yourself up on the local laws. Okay, the first potential defense for a defendant in a negligence case is very straightforward, and we've kind of already even covered it just by looking at negligence from the plaintiff's perspective. Probably the best and easiest defense for a defendant is attacking those four elements. So proving no negligence, essentially. So if you're the defendant and you can disprove one of those four elements that we looked at last week, duty, breach of duty, causation, damages, if you can disprove just one of those, then you can prove no negligence, right? And the case won't move forward. So, a good legal team is initially going to look at those four elements and try to figure out how they can potentially poke holes in one of those elements. And remember, in order to prove negligence, the plaintiff has to prove all four. So if even one of those doesn't exist, that would favor the defendant. Another potential defense available in a negligence case is called comparative negligence. Just as the title suggests here, essentially in using comparative negligence, the defendant is arguing that the plaintiff had some level of fault in the incident, right? So they did something, or their actions in some way played a role in causing their own injuries, and therefore the court should take that into consideration when they're determining fault. So comparative negligence basically is just arguing that, the plaintiff had some role in this, and therefore we should either reduce the amount of damages that they are rewarded or get rid of them altogether based on the percentage of fault. So there are basically two different types of comparative negligence, as you can see here. We have some states that follow this pure comparative negligence, and we have others that follow this modified comparative negligence. And I'm going to tell you a little bit about the difference here, and then we're going to actually apply it to an example. So in pure comparative negligence states, as you can see, the award of the plaintiff is reduced by the percentage of fault assigned. So if you remember back to our case that we looked at in class last week, this was the case involving Becca Stevens. We know Becca was deemed to be awarded $1,500 based on the injuries that she suffered in that case. But what if we change things up a little bit? What if we find out that the security footage shows that instead of just walking through the facility, she was actually sprinting, right? She was running late, so she was sprinting. Well, if that evidence comes to light, the defense could argue that Becca played a role in causing her own injuries, right? She increased the risk of falling by sprinting through the hall. That doesn't mean that the wet spot didn't play a role in causing those injuries, but that she also played a role in that. So if that were the case, the court might then define that, yeah, she's 60% at fault for the fall. Now, in a pure comparative negligence state, that would then reduce her total damages awarded by 60%, okay? So again, the award of the plaintiff is reduced by the percentage of fault assigned. So you would simply reduce this award, which was deemed to be a $1,500 award, by 60% in order to determine what she would actually receive. Now, in a modified comparative negligence state, it's a little bit different. It doesn't look at the percentage of fault to determine the decline. It basically uses this threshold of 50%, right? So if the court finds that the plaintiff was 50% or more at fault for their own injuries, then they get nothing. But if that percentage of fault falls under that 50% threshold, then they would still receive damages. So it basically just uses that 50% as a threshold to determine whether or not, the plaintiff played enough of a role in causing their own damages to reduce their award. Okay, so I've broken down pure comparative negligence and modified comparative negligence. So based on what you've just learned and what you've read, I want you to determine how much the court would actually award Becca in both scenarios. So both in a pure comparative negligence state and a modified negligence state. So go ahead and pause the video and take a few minutes to do that math, and then we'll come back and go over the answers. Okay, so again, we know in a pure comparative negligence state, we're reducing the award based on the percentage of fault assigned to the plaintiff. And we know in Becca's case, the court has now deemed her to be 60% at fault for her fall because of her running down the hall. So it's pretty simple math, right? We know that the original award was $1,500. We can do a quick math and find out that 60% of $1,500 is $900. So we would just then reduce her total award by that 60%, which is $900. That would leave Becca with $600 in damages. So she's still getting something, but that total award has been reduced based on her level of fault that the court has deemed appropriate. So that's a pure comparative negligence state. In a modified comparative negligence state, remember, we're basing it off of that 50% threshold. So in this case, we know that the court has deemed Becca's fault to be 60%. So it falls above that 50% threshold, right? So essentially, it's more her fault than it is of the facilities, right, based on that percentage. So in a modified comparative negligence state, that would mean that she gets nothing. Right? Now, had her percentage of fault fallen under that 50%, she still would have gotten a portion of that award. But because it is above the 50%, she gets nothing. I should note, too, that Illinois operates under this modified comparative negligence standard. All right. So another potential defense available in a negligence claim is what we can know as contributory negligence. Now, I want to say, take this one with a grain of salt because there are very few states that utilize contributory negligence, or allow it, I should say. The vast majority of states operate under some kind of comparative negligence standard, and not that many. I think it's 4 or 5 states that are left that still allow a contributory negligence line of defense. And you'll see why here as we talk through it, I think. So contributory negligence is similar to comparative negligence in that it's looking at the level of fault by the plaintiff. So it's acknowledging that, hey, the plaintiff played some kind of role in causing the accident, and that should impact the overall award. Now, the reason contributory negligence is used by so few states is that, as you can see here, under contributory negligence, any percentage of fault by the plaintiff is going to lead to a complete bar on a negligence claim. So even if the court decides that Becca, for instance, is 10% at fault for her injuries, in a contributory negligence state, she would get nothing, right? So any level of fault by the plaintiff in a contributory negligence state means nothing, basically throws the claim out. So you can see that this is sort of an extreme version of comparative negligence. And again, that's why so few states actually allow it, because it makes it very difficult for anyone to sue for negligence, right? Because, most defendants could argue a plaintiff played some role in contributing to their own actions. So again, if we look at Becca's scenario again, if she was in a contributory negligence state, it wouldn't matter what her percentage of fault is. She would get nothing as long as the defense could show that she somehow played a role in her injuries. Okay, the next type of defense we're going to look at is assumption of risk. And this is a very common defense utilized in the field of sport and recreation. And I think you'll see why here after we look at it a little bit closer. So basically, if you're using an assumption of risk defense, you are arguing that the plaintiff who's filed suit knowingly signed up for these risks, right? They voluntarily exposed themselves to what we've termed inherent risks. And if you'll remember from last week's unit, we defined inherent risks as known risks associated with an activity that tend to be well known, that are associated with that particular sport or activity. As you can imagine, in sport in particular, there are a number of inherent risks. Name any sport or activity associated with sport, and you can probably list a handful of inherent risks associated with that activity. So it's not uncommon for a sport organization or a sport practitioner to utilize the assumption of risk defense, because it tends to be fairly straightforward. And in the next few slides, we're going to identify the different ways you could potentially prove that someone knew they were exposed to those risks. So there are basically two different ways that you can show or prove assumption of risk in negligence defense. So first of which is expressed assumption of risk. So here, basically, the participant or the plaintiff has given some kind of advance consent, and expressly, usually this is written, right? They've signed something, agreeing to accept the inherent risks of an activity. So if you're a sport organization, express assumption of risk is really your best approach here, right? Because having some kind of written situation or any, maybe even a verbal situation where the plaintiff has acknowledged these risks beforehand, before taking place in the activity, that's going to be your best line of defense under assumption of risk, right? Because you have actual evidence or proof that they knew these were the risks, yet they chose to participate anyway. We'll talk about waivers in depth here in a minute, which is going to be probably your best proof of express assumption of risk if you're a sport organization. But before we get there, there is another way to prove assumption of risk, and that's through implied assumption of risk. So here the risk is just presumed when a person or individual voluntarily participates in something that generally has well-known risks, so those inherent risks that we've been talking about. So implied assumption of risk can certainly be utilized and often is utilized as an argument by sport organizations. But as you can imagine, it's a little bit harder to prove implied assumption of risk, right? Because you don't have that expressed assumption of risk where someone has actually written that they acknowledge the risks or they verbally agreed to acknowledging the risks. Here, they're just implied, right? Because they're well-known risks. Okay, as I suggested on the last slide, probably the best proof a sport organization can have for proving assumption of risk is a waiver, right? A signed and completed waiver by the plaintiff showing, hey, not only were they told about these inherent risks to this particular activity, but they actually signed and said they were not going to sue. They were essentially giving up their right to sue in those instances. So really quick here, I know we're probably all familiar with waivers. You've all been asked to sign waivers at some point as a participant. Some of you might have asked others to sign waivers as part of your GA or an internship that you've completed. So we'll have a general familiarity with waivers, but just so you have the actual legal definition, a waiver is, in fact, a contract, okay? It's a contract in which a participant or user of a service agrees to relinquish the right to pursue legal action against the service provider in the event that the negligence of the provider results in an injury to the participant. Now, one thing that I definitely want to make clear here that I think isn't always clear from just reading a waiver is that waivers only protect the sport organization or organization from legal action in cases of ordinary negligence. So if you remember back to our conversation last week, we said there are different levels of negligence, right? And historically, the courts have said waivers only cover service providers in those cases of ordinary negligence, right? They do not cover sport organizations in cases of reckless conduct or intentional action or even the highest level of negligence, which might be deemed gross negligence. So important to remember that these waivers are only covering organizations in cases of ordinary negligence. It's also very important for us to acknowledge that the validity of waivers, so whether or not they're actually upheld in court, is not a guarantee, okay? So there are a lot of factors here, but basically, to kind of sum it up, courts do not like it when people sign away their right to sue, right? Think of it from a judge's perspective. Their job is, of course, to, actually uphold contracts. That's certainly a portion of what they do, but they're also there to make sure that people who are wronged or injured by an organization or an individual are put back into the place that they were previously, right? We know that from our definition of tort law. So it's kind of a tough balance for courts and judges, but the truth is they do not like it when people sign away their right to sue. They want people to be able to follow through if something bad happens to them. They want them to have the legal right to sue. So that's an important thing to remember, that not all waivers are going to be upheld. That waivers are only upheld if they are both well written and follow the necessary legal requirements. And we're going to go over those legal requirements here shortly. But I do just want you to keep in mind that some courts will allow a waiver to be used as a very strong defense, where other times courts may throw out waivers altogether. And it depends on the jurisdiction, it depends on the judge, it depends on a lot of different factors. So you should never assume that a waiver, even if it's well written, is going to be able to be a sure-proof defense for your sport organization. It can certainly be a defense and it can be helpful in making your case, but there should not be an assumption that it will 100% be accepted every time, especially in instances where children are involved, so people under the age of 18. Courts, especially here in the state of Illinois, have said previously that they do not like it when parents sign on behalf of their children, and in fact often throw those waivers out because of this issue of consent, right? A child or a non-adult cannot technically consent to signing a waiver, and that's why their parents have to sign on their behalf. And historically, courts do not like that. All right, so let's look now at some of the legal considerations for a valid waiver. We said that it's not a guarantee that a waiver will be accepted in court or by a court, but there are some things that could be taken into consideration that will boost your chances of having a solid waiver. So these are some of those considerations. First, a waiver has to be clearly written and easy to understand. Now, what does this mean? It means that a layperson, someone who hasn't taken a law class, hasn't gone to law school, should be able to read your waiver and understand what it is that they are signing, right? It can't be so technical from a legal perspective that they have no idea what they're reading and therefore can't really consent to it, right? So as important it is to include some specific legal terms, and we'll talk a little bit more about that in a bit, a waiver has to be clearly written so that it is easy to understand, and that will certainly be a consideration of the court when they review it. This next one is pretty straightforward, right? It must be made obvious that it is a waiver. So this one, pretty easy to fulfill. You make sure that at the top of the document that it is clear that it is stated as a waiver and that it is a legal document, and not that it is just added to the bottom of something like a participation form or something like that. It needs to be very clearly stated that it is in fact a waiver and thus making it a legal contract. Like I mentioned previously, really a waiver is really only useful when it is signed by someone who's of majority age, so someone who is 18 or older. And this is specifically true in Illinois, right, where we said that the courts essentially do not value waivers that are signed by parents on behalf of their children, right? So the strongest waivers are going to be ones that are actually signed by someone of majority age. We'll talk in a little bit about how a waiver signed by a parent might still be useful to support other defenses, but just know that a waiver signed either by a child or by their parent is going to be difficult to uphold on its own in court. Okay, waivers should be written specifically for your business. I'm going to take this one in two parts. Okay, so let's start with this first part. So this is something I always see with sport organizations. They will find a good waiver that they like by a competing business or a similar business, and they will simply copy and paste that document for their own use. Now, this is an issue because obviously no business is exactly alike, right? There are different risks associated with your sport organization than there are other sport organizations, even if they do some of the same things. Facilities are different. The hierarchy of employees is different. There are a bunch of different factors that are going to change what your waiver should say versus what another waiver should say. So this goes into part 2 here, which is that potential risks should be clearly and specifically stated. The more specific the sport organization gets in outlining the potential risks, the more likely that waiver bill will be used in court and upheld in court. So if you can clearly define the specific risks associated with your organization or your facility, then the more likely you are to be able to go back to that document and say, hey, these were the risks that we had outlined, and this is why this person, agreed to this waiver, and therefore we're not liable. So one, make sure that waivers are written specifically for your business. They're not just copy and pasted boilerplate from another organization. And then when you are updating that waiver to be specific to your organization, make sure that you're specifically identifying risks associated with what you do at your facility or with your organization, because the more specific it is in outlining those potential risks, the more likely it's going to be used as a defense. All right, this last consideration that I want us to talk about is that a waiver must be signed voluntarily. You might be thinking, well, duh, of course it should be signed voluntarily, right? We can't force someone to sign a waiver. But as you'll see here in a minute, this could be tricky, and there can be a little bit of a gray area here, especially when it comes to the relationship between powerful people and sport organizations and maybe less powerful people that they're asking to sign a waiver. But legally, a waiver has to be signed voluntarily in order for it to be upheld in court. Now, to reference what I was talking about there, I think I'm going to use a very recent example and one that's still ongoing, and that is the use and enforceability of COVID-19 waivers across the sport industry. You've probably seen articles about this, or maybe even have had to develop one for your own sport organization or department. But a number of university athletic departments, professional teams are basically creating these COVID-19 specific waivers that they're asking participants, student athletes to sign, right? Because they're actually participating in sports in the middle of a global pandemic. So this goes back to our last consideration there in terms of signing voluntarily, and that there's some questions here about whether or not the student athletes that are being asked to sign these are actually doing so voluntarily, right? Basically, this is a major question about whether or not these will be enforceable down the road if, in fact, student athletes have long-term health issues related to COVID-19. And what I'd love for you to do is go read this great article by Michael McCann. He's a great legal writer, and he's basically broken down a bunch of different reasons why these COVID-19 waivers may not be enforceable. And one of the reasons he talks about is this concept of voluntary or not, right? And whether or not, an athletic department telling a student athlete, hey, if you don't sign this waiver, you can't participate in your sport, is actually giving them the ability to volunteer and sign that waiver, or whether or not they're being forced to, essentially. So yeah, go check that article out. It's really good. I put it under the ReggieNet module for this week. All right, so we've talked about waivers. We've looked at some of the common legal considerations for a valid waiver. I do just want to mention a few other points here before we move on to the next defense. And that's that when we think about the use of a waiver, outside of it being its own defense, we know that it can also be a really strengthening of the assumption of risk defense, right? If we look back at the definition we gave for that express assumption of risk defense, we know that something in writing is really helpful, right? So if we can go to the court and say, hey, maybe this waiver can't be upheld on its own, but it could certainly strengthen our assumption of risk defense, right? Because at least, at minimum, we can show that they did sign off and they had acknowledged that these were some specific risks associated with the activity. So even if the waiver itself is thrown out, you could still use it as a supportive system, or a supportive document rather, for the assumption of risk defense. Another thing to mention here, and this goes back to the under 18 and whether or not a parent should be able to sign off on behalf of their child issue. And what you will often see here in the state of Illinois is plenty of SWOT organizations are still asking parents to sign off on a waiver on behalf of their child, even though they know a court is likely to throw that out. And one of the reasons is that, parents generally do not know that, right? And many of you probably didn't know that before taking this class, right? So, sport organizations use that to their benefit, right? They know that the general public probably doesn't understand the nitty-gritty of waiver laws in the state of Illinois. So they're still going to ask people to sign them, knowing that it likely reduces the chance of a lawsuit, right? Because if someone signs a waiver, they automatically assume that they've signed away their right to sue, even though we know in certain cases that's not true. Sure, that opens up some ethical questions, and certainly that's worth discussing. But note that, in addition to serving as a potential defense on its own, in some cases, it just reduces the likelihood of a lawsuit because people assume that no matter what, they've signed away their right to sue. Okay, another type of defense available to sport organizations or practitioners is known as immunity. So pretty common term that you're probably aware of. In this context, we're talking about immunity being the freedom or exemption from legal penalty or liability under negligence. So what you'll see here and through your reading is that there are basically 4 different categories of immunity that apply in the sport industry. And I'll briefly go through these here, but certainly encourage you to read more on your own. One thing to note, just as we did with negligence, is that these immunity statutes typically only apply in cases of ordinary negligence. So just like with the waiver, it's only going to protect someone in those ordinary cases of negligence, not reckless actions or intentional actions. The general philosophy surrounding this idea of immunity is that basically we have groups of people in society that are willing to provide a service, essentially, and because of that, in exchange, we want to provide them with some level of protection from legal action. And you'll see that that's a common thread through all of these different types of immunity in the sport industry. So governmental immunity, with certain positions within government, so you're a government employee, that's going to provide you with a level of protection, right? And the historical basis for that is, typically if anyone sues the government, the money that they would obtain is through tax dollars, right? So, the idea is we don't want people just able to sue the government or government officials at all times because they're essentially just taking tax dollars out of the system. Not great. Recreational use immunity. This one essentially applies to people that are willing to provide access to their land. Say they live on a large piece of forest area and they allow recreational use for hunting. Right, that would be an example of recreational use immunity where we would provide a layer of protection there from legal action if someone were to get injured on their land. Because they're willing to provide that land for free, they get a level of immunity. Same goes for the charitable or volunteer immunity. So this one in our field, it really applies to people that volunteer their time as coaches, umpires, that sort of thing for nonprofit sport organizations. basically, in 1997, in the Clinton administration, they passed this Volunteer Protection Act, which provided a level of immunity. Basically, if people are willing to give their time for free to volunteer and coach and referee for these young kids, then we don't want them not to worry about being sued if something goes wrong. And then finally, this Good Samaritan statutes, basically if someone goes out of their way to provide assistance to someone in harm. So if someone sees someone choking, they go over and try to provide them care in a shopping mall or at a sporting event. This Good Samaritan statute provides them, a level of immunity in case something were to go wrong. Again, we want people to be encouraged to try to help others if they see someone in need. So we don't want them to worry about legal action. Okay, so the last type of defense I want to mention here, and then we'll wrap up this first video, is procedural noncompliance. So these defenses, unlike the other ones we've looked at, don't really have to do with the facts of the case necessarily. They have to deal more with some of the behind-the-scenes procedural things that are happening legally. And essentially, the defense is trying to point out something that the plaintiff's legal team did wrong that would get the case thrown out, right? Basically, the plaintiff didn't follow proper legal procedures, and that's going to be enough to throw out the case. So here's a couple examples of that. We talked about this concept of jurisdiction in our first module. So again, cases have to be brought to trial in a court that has jurisdiction or the ability to actually hear the case, right? So if the case is filed in the wrong jurisdiction, let's say it's filed at the federal level when it could only be heard at the state level, then that could be an example of procedural noncompliance. Another is statute of limitations, which you may have heard about. Basically, there are certain restrictions on the length of time an injured party has to file a lawsuit. In some cases, like negligence, it might be 2 years that they have from the incident taking place to file a case. If the plaintiff waits beyond that 2 years to file the case, that would be an issue of procedural noncompliance, and the case could get thrown out. So pretty straightforward there. Procedural noncompliance is going to be, the legal team for the defendant searching for some kind of legal error that occurred to get the case thrown out. Okay, I'm going to pause here, and your next video is going to cover the different negligence applications.